Happy Thursday. Welcome into Studio B. Great to have you with us today. We're really happy about the lineup we have on tap today for you. If things looked bleak for former Virginia Governor Bob McDonnell the day he was convicted on numerous charges, and they did look bleak, well, they're looking much better now. McDonnell's appeal has been granted. He remains a free man. And this week, the 8 justices of the U.S. Supreme Court heard his case. And there's growing speculation that he may, repeat, may, ultimately prevail. We turn now to 2 men who've been covering the case closely. Ken Jost writes the Jost on Justice blog. Reporter Michael Pope is with Virginia Public Radio. Gentlemen, it's great to have you with us. This is a big deal, this case. It's being watched closely. I think it's completely fair to say that how this case gets decided, and it's page 1 in the Post today, the former governor still out, still walking around, still a free man despite his conviction by a Richmond jury on a list of charges following a blockbuster trial. This goes, as important as it is to Mr. and Mrs. McDonnell and the Commonwealth of Virginia, politicians across the nation, Ken, are watching this thing to see how it gets resolved.
That's right, and let's just underline first that he is still proclaiming his innocence. Walked out of the Supreme Court after the hour-long arguments on Wednesday and stood in front of the microphones and said again, "I've never abused my office." Took no questions, but that was his position, firmly stated, just as he stated it at the time of the indictment, at the time of the conviction, now 18 months ago or so, right? In the appeal, we should have known, because the Supreme Court allowed him to remain free even before they had decided to hear the appeal, we should have known that there was sentiment among the justices that this conviction was a bridge too far. And boy, did it sound that way. You had the Chief Justice, Justice Kennedy, and Justice Breyer, those 3 in particular, seemingly certain to overturn the convictions, 11 counts, the convictions as they now stand.
Michael, take us inside the court.
Well, the mood inside the courtroom was, just as Ken pointed out, very favorable to the governor. I think the governor probably had the best night's sleep he's had in a long time last night after the hearing yesterday. And I agree with your head count of the justices too. I think certainly Breyer, I would say, was the most adamant about sort of drawing criticism of the case against the governor. One point he kept coming back to again and again was the potential for prosecutorial overreach. The point he was trying to make is a prosecutor, a federal prosecutor, could really abuse this statute if they wanted to go after any elected official for doing the most minor of things. Like, for example, elected officials often write letters to other government officials,
sure,
mainly
agency heads,
mainly to get the constituents off their back. I mean, this sort of came up, like if you got a constituent that says, "I've got this really bad problem with the Justice Department."
You want to be able to say, "I called so-and-so, I sent them an email."
You want to write the letter and get it off your back. So elected officials do this all the time. And so the McDonnell charges were, there was a sensational, sort of eye-popping, let me say that instead. There was this kind of an eye-popping sense of the gifts that the businessman Johnny Williams lavished on Governor Bob McDonnell while he was in office. Charges were brought. That's big. A conviction by a jury that heard the case was returned. That's big. What is it that the justices are potentially seeing that is so at odds, potentially, with what the jury saw during that whole amazing trial?
Well, the case that was argued in front of the Supreme Court was, in some sense, the same case that was argued in front of the jury, but it was reduced to its essentials. And so instead of $175,000 worth of gifts, yesterday in the courtroom, we were talking about a bottle of expensive wine or an afternoon of trout fishing, okay? And Justice Breyer, indeed, was one of the people who said, "Oh, when I was at the Antitrust Division, I might have gotten a letter asking for my help on setting up a meeting." And indeed, what did the governor do? He helped set up meetings. He hosted an event. He hosted an event, and McDonald's attorney started and ended with this this phrasing: "It's not an official act unless the public official does something or urges someone else to do something." Noel Francisco, representing McDonald's, said the governor didn't do that. The governor has maintained throughout, "I didn't do anything like that."
You know, on that point, the part that's really interesting about this case, one of the many things that's interesting about this case, is there's a whole lot of quid, but the quo is where things get sort of murky,
the
right?
old quid pro quo, this
right,
for that.
yeah, there's a whole lot of this, which is the expensive gifts, the loans, you know, the expensive cognac, but the
ride in the Ferrari.
The ride in the Ferrari, infamously, the Rolex watch. But the quo, in other words, what did this businessman actually get out of this is really murky. And so that's where you saw the justices struggling with this.
Sorry to interrupt, but with the argument being that Bob McDonald, a skilled lawyer, the former Attorney General of the Commonwealth of Virginia, knew the line and might have gone right up to the line, but was careful, obsessively careful, he will argue, not to cross the line. So guilty of unseemly, probably. Guilty of illegality, they maintain and have since the beginning, no sir.
You know, you point out that McDonald has a background as a prosecutor. He's the former attorney general, you know, a sharp legal mind in his own right. Wouldn't it be great to get the Bob McDonald legal analysis of what happened in the Supreme Court, like to be inside of his head a little bit? Going back to what I was saying earlier, this is the quid pro quo. So the real debate is, what did this guy actually get out of this?
Right.
And did the government make their point? Justice Kagan had a really interesting series of questions toward the end where she said to the government lawyers, you know, you were doing this wrong, essentially, or you may have been doing this wrong by sort of putting points on a map, but then not sort of charging the end result. For example, the charge wasn't that the governor illegally tried to influence university officials. The charge was he hosted a party at the governor's mansion, and he gave Johnny Williams the ability to put together the guest list. Those are points. It's not the conclusion. So I think she was also potentially setting the stage for a second trial. That's another scenario that could come out of this. As you overturn the conviction, you try McDonald again on potentially different charges and in obviously different jury instructions.
We should say something about what the government attorney did. Michael Driedman, a 27-year veteran of the Solicitor General's office, making his milestone 100th argument in front of the court. Wasn't his best day ever. But he did have some points. As to the meetings, he told Justice Breyer, look, the average citizen can't get the governor to set up a meeting. Preferential access for this businessman to get a meeting with the university people.
That's interesting. I could see that carrying some weight.
And
there were gifts that the average citizen doesn't give, and there were things that the average citizen doesn't get, and you'd have to be blind not to see the connection.
And Ginsburg, one of the two justices who might vote to uphold this conviction, Ginsburg said at one point to McDonald's lawyer, so citizen pays money and says, here's the money, will you set me up a meeting? Yep. You want that to be legal?
And that's why, and that brings us exactly to where I wanted to go next, Ken. And you know, Michael, every politician I talk to, maybe not every, but so many of the politicians I talk to, and have since this case, at the very local level, county council types, on up to the state legislature, and north to the members of Congress. They're all watching this case because everyone has some entity in their district, an employer, a corporation, a somebody, and if you're doing your job as an elected official, you care about the employers and the corporations in your district. Their health undergirds the health of undergirds the sort of the economic health and vibrancy of your area, right? So it's okay for elected officials to have relationships with and to help, to the extent that they legally can, the corporations and companies and employers in their area. And they do this. I would say clearly part of the gig. And there are contributions. And the public wants to know that acts aren't being done because contributions have been given and received. And that's what makes this case so interesting beyond whether Bob and Mrs. McDonald stay out of prison.
The classic example that keeps an elected official up at night, and you hear them talking about this sort of thing, is, you know, what if I go to the Rotary Club breakfast and they give me scrambled eggs, and then the president of the Rotary Club says, I got this problem with the DMV, could you set up a meeting with the DMV? Well, then you are theoretically guilty of exactly the same thing that Bob McDonnell has been convicted of, and that is behavior that
sold
takes place
your office for eggs.
That is behavior that takes place every day, and so this is what Justice Breyer was trying to say. If you take the logical conclusion of this conviction to the extreme, and you have an overzealous prosecutor, he could go after
or politically motivated prosecutor from a different party or whatever, doesn't like the person.
And Dreeben, in response to this, says, well, you just need to trust the jury. A jury of 12 people is not going to return a conviction for scrambled eggs, but they will for a big one. And to that, Justice Kennedy said, well, that's not very much by way of reassurance to the public official. Oh, well, you might not get convicted. Not good enough. And it was interesting, in the ordinary criminal case, you have a bunch of people supporting the government and hardly anybody supporting the criminal defendant. The exact reverse here. 16 amicus briefs filed by, among others, the White House counsels for the past 5 presidents, bipartisan group, and the Chief Justice Roberts emphasized that at the start of his tough questioning for Dreeben.
We are at and beyond our time, but we'll wrap by discussing just for a second the death of Antonin Scalia, which has the court at 8 and not 9. If they deadlock, and it appears that this may not be the case, it could be 5-3 for McDonnell without, so the concern might not manifest itself. But if there's a 4-4 deadlock, does the appeal stand?
The 4-4 deadlock, the lower court wins.
Does the conviction stand?
The conviction stands. And as Michael suggested, the case might not be over. There might be a retrial. There was a case, people might remember the Enron executive Jeffrey Skilling won at the Supreme Court, but was reconvicted when it went back down. So that could happen here.
Michael Pope, Kenneth Jost, interesting case. Thank you very much for your analysis. Really good to be able to touch on this topic in a big way today. Thank you both so much for your time. We'll step aside. Attorney General Carl Racine is next. Please keep it here.